He's really happy, doesn't he? He's so
Yeah.
positive for a rules change.
Yeah.
That's not right.
Okay. All right. Okay. Are you through? Okay. All right. On the wall, Mr. Green, would you please open us?
Let us pray. Our dear Heavenly Father, as we gather here this morning, may we come with open hearts and open minds, oh Father, as we do the state's business. And Father, we as your servants want to do what is right for this great state of ours and our country. And Father, we pray for our troops that are guarding this country, that are stationed all over the world. We pray for their families. And Father, keep them safe. And now, Father, go with us through these proceedings and bless us and forgive us of our sins and shortcomings. Guide us in the days ahead. In thy holy name we pray. Amen.
Thank you. Good morning, everybody. On the wall, you lined up around. It's 15 after 9. How quick can you be? Mr. Sims.
Is this on? Okay. Mr. Chairman, ladies and gentlemen of the committee, I'm bringing 4 bills this morning. I've been working on your local bills. I'm down to about 180 this morning, 185 I think. We're going to have 28 on, so y'all be considerate today. It's my first time in the rules. I apologize to you for not getting here any sooner. First one on the list is House Bill 953. This first page on the blue sheet, bottom of the page, last one. This is a consumer protection bill from the funeral industry. Several years ago, Mr. Chairman, we put cemeteries and funeral homes together inadvisedly, and we're trying to separate those two industries at this point in time with their different and separate boards. That's basically what this bill does. It is very important to that industry. There's about 500 funeral homes that are seeking this legislation all over the state. It had no opposition anywhere, either in committee or anywhere else, but it is a very, very important bill to the industry and to the consumers of this state that we get this fixed. It has to do with trusting and many items that are in there that we had to separate from both industries. Both industries are very much in favor of the bill, and we're moving along with it. The other 3 bills I'll explain very quickly are House Bill 1119 on page 2, 1120 and 1121. All of those are change probate and magistrate judges from partisan to nonpartisan elections in my part of the world. That's all they do, Mr. Chairman. Thank you.
Any questions? Thank you. Mr. Williams.
Mr. Chairman, I don't think I'm on the blue sheet.
What number?
1055, 65.
I've got you all over the place on this thing. So.
Thank you, Mr. Chairman, members of the committee. I have 2 bills that were requested by the Revenue Department, upgrading their statutes. 1065 has some grammatical changes on it. It clarifies records retention, unified reporting date for alcohol excise taxes, removes current unnecessary language that creates confusion, and clarifies reporting and remitting dates. 1065 and 1066 provides for annual expiration date. They're trying to stagger the license renewals so they don't all pile up at the end of the year. Creates greater local control over measures of the minimum distances that from churches, all the churches and public schools, as far as the distances that would be now is a direct line. It clarifies when occupational taxes are due. Basically, that's what it does, Mr. Chairman and members.
Any questions? Thank you. You're good.
Thank you, sir.
Y'all, we need to congratulate Roger for getting here this morning. He has this problem with mornings. Mr. Coleman.
Thank you, Mr. Chairman, members of the committee. I'm here today to ask for two bills on page 3 under modified structure, House Resolution 1150, down about midway, and then under structured rules, House Bill 896. And basically what these are, they go along with the capital outlay. That's the SPLOST, the distribution of money from the SPLOST proceeds that they will be distributed by per pupil allotment. And 1150 is the constitutional amendment that allows this, and 896 is enabling legislation. I've talked with you about this before. If there are any questions, I'll be glad to answer them.
Mr. Roberts.
Thank you, Mr. Chairman. Mr. Chairman, just some clarification, and I apologize that I hadn't read the version as it just come back to us. Under this, does this got anything to do with part of the SPLOST can be spent for M&O?
No, sir. That's nothing to do with the M&O. No.
Okay. All right. Thank you.
It's just the way we'll distribute the funds based on per pupil.
Mr. Maddox.
Thank you, Mr. Chairman and members of the committee. My bill is about halfway down the first page, HB 746. This is basically a 6-line clarification bill that deals with administrative review by the Agriculture Commissioner. Right now you have an initial decision that's made that can be appealed, and then the Commissioner makes a final decision, and then that can be appealed for reconsideration. Right now in the code, the final decision and the reconsideration decision are referred to as a final decision, a little confusing there. So we're basically clarifying the language as to what is the final decision, what is the reconsideration decision, and the time frame for asking for each.
Any questions? Thank you.
Thank you.
Mr. Maxwell.
Thank you, Mr. Chairman. House Bill 208, number 2 bill on the front sheet under modified open. This is changing the sunset date for teachers that have retired, drawing full employment from the TRS. We allowed them a few years ago to go back to work full-time in needed areas. Right now we've got students graduating from college who can't find jobs. We're moving the sunset date up from 2016 to 2013 to just shorten the time frame for these back-to-work teachers. And I'd ask for y'all to help me get that out. Thank you very much.
Any questions? Thank you. Ms. Purcell.
Mr. Chairman and committee members, I'm back with you. House Bill 268, Modified Open Rules. This is for the zoning procedures and actually clarification adding to the signs that will be posted on property, and also would add to the fact that adjoining property owners of the areas that are going to be zoned, that they would be receiving by U.S. mail, not certified, but by U.S. mail notification that a zoning is going to be changed. Appreciate your consideration and placing that on our calendar. Also, I have one other bill, if I may speak to that, Mr. Chairman.
Yep.
It's under Modified Structure Rules. House Bill 161 is brought to you as a substitute from the committee. This is regards to partial inoperable red lights that occur throughout our state. And it also helps not only motorcycles so that they can proceed with caution, but also helps the small vehicles that are now being made for the efficiency with the gas mileage and the gas prices as they are today. This is an approach taken for a Mobility Safety Act in regards to what the laws already are for flashing red light, what vehicles have to do on that, as well as the flashing yellow lights, which is a caution light, and then you will see the third new section, which is a partially inoperable red signal. What is the proper thing to do for safety and to proceed through that? If there are not any questions, Mr. Chairman, I would certainly ask for consideration of this being placed on the calendar.
Any questions? Mr. Roberts.
Thank you, Mr. Chairman. Chairman Purcell, is this bill, is this the bill that we've been working on?
Beg your pardon?
This is not just the red light camera bill concerning.
That is correct. It still does with the same thing with the traffic signals with the sensors, whether they're in the asphalt or whether they're the sensor cameras that are not being efficient enough to let small vehicles, whether it be a motorcycle, a small car, because of the weight and the metal that is contained in them, to know what to do if they're at a partially inoperable red light when you can't trip those signals.
Okay, thank you, thank you.
Thank you for the question.
Thank you.
Thank you.
Mr. Parsons.
Mr. Chairman,
Yes, sir.
Okay, I didn't hear you call me. Thank you. First bill, or I have two bills. First bill is House Bill 520. House Bill 520. What this bill does increases the percentage of the annual peak demand from the previous year that a electric provider can buy back from those people that have solar panels on their roofs. And that's all it does. It doesn't change the price. It still would be, the price that the electric provider pays would still be at the avoided cost. It doesn't change anything regarding that. It just increases the percentage. There's no opposition to this. In fact, the electric providers see it as a positive thing. Any questions? I'll be glad to try to answer those.
Mr. Weldon.
Thank you, Mr. Chairman. Chairman Parsons, does this bill provide for the contribution of those folks that are selling this energy back to traditional providers for the infrastructure that they've got installed over the years?
They buy it back at the avoided cost. In other words, they buy it back at what it would have cost them to provide the peak energy during the peak hours anyway. So it's not costing them anything more. So yeah, I mean, they recoup for that, absolutely.
Thanks, sir.
And it has nothing, and I just also add, it has nothing to do with there's some bills over in the Senate that do a lot more, a lot of different things. This has nothing to do with any of that.
Next bill.
Next bill, I'm sorry. I'm having trouble hearing, I guess. Next bill is House Bill 934. This bill has to do with the energy savings performance contracts that governments enter into. It does away with the requirement that these are only that bids are only given out every 3 years. There's so many changes in technology that to wait at least 3 years to give out new contracts, it's really not beneficial or efficient for state government. And that's the first part of it. The other is there's a lot of cleanup language in here that was brought to us by the Municipal Association. I think the original bill that was passed was based on a bill from another state. Doesn't necessarily apply to our laws and our makeup of municipal governments in the state of Georgia. It's cleanup language, and there was no opposition to that either.
Any questions? Thank you. Mr. Chokas.
Thank you, Mr. Chairman, members of the committee. On page 3, modified structure, I bring before you Senate Bill 339, and it simply takes the aviation assets out of the Georgia Aviation Authority and gives them back to the Department of Natural Resources, State Forestry Commission, and the Department of Transportation.
Any questions? Thank you.
Thank you.
Mr. McKillop.
Thank you, Mr. Chairman, members of the committee. On page 3, structured House Bill 54, I bring before you what is known as the fetal pain bill. Simply put, it to put an end to abortions at 20 weeks and later, except under certain circumstances. It provides for definitions. It came through judiciary non-civil on an 8-3 vote. Happy to answer any questions.
The minority leader.
Thank you, Mr. Chairman. Mr. McKillop, I have 4 questions for you. The first question is it not true that a woman at 20 weeks who discovers that the fetus that has the umbilical cord wrapped around its neck and has no heartbeat, under the terms of 954, unless it poses a serious medical risk to the woman, this woman will be forced to carry the fetus to term?
If the fetus has passed away, I believe that the pregnancy can be ended.
No, not that the fetus has passed away.
If the fetus doesn't have a heartbeat, I believe it's passed away.
That's not my question, sir. My question is, if the umbilical cord is wrapped around the throat of the fetus, which may not immediately result in death, but almost uniformly results in death upon delivery, is it not true that under the terms of this bill, the woman will be forced to carry this child to term?
The terms of the bill are that any pregnancy that exceeds past 20 weeks that doesn't result in a serious threat to the life or a bodily condition of the mother will continue.
Thank you. The second question is it not further true that current medical science, including the Journal of the American Medical Association and the Royal College of Obstetrics and Gynecology in 2010 indicated that 24 weeks is the earliest that fetal pain is possible, contrary to the study that you've relied on, which is 18 years old?
Other studies disagree with that. I understand that study exists. Other studies disagree with that, and I think that there's good evidence, including what we found in this body in 2005, that fetal pain exists, that fetuses respond to stimuli of pain at 20 weeks, that is the point at which we can demonstrate a compelling state interest to overcome the woman's right to privacy and prohibit abortion.
Are any of these studies post-2010?
I believe that there's sufficient evidence, and the studies are not post-2010, including findings of this body of 7 years ago, that fetal pain exists and can be experienced at 20 weeks, and that is the compelling state interest which gives us the right to prohibit abortions at that time.
Is it not further true that this bill condones the torture of medically futile fetuses who may have encephalitis or some form of brain disease? They will feel pain as of 24 weeks, but under the terms of this bill, they will not survive post-utero, but will be forced to be carried to term, even though they will be in torment and excruciating pain during the term of their gestation.
I understand that is the lady's position. I think that many of the conditions of which the lady is mentioning result in a complete breakdown of the structures necessary to feel fetal pain at all, and so no, not in some circumstances.
But if not in some circumstances, then yes in others?
It's possible.
Thank you. My last question is, and going to your position on the posture we took in 2007, is it not true that you opposed the Women's Right to Know Act in 2007? And if you believe that you were wrong then, is it not possible that you are also wrong now?
I agree that I was wrong then, and I am looking forward to correcting that tomorrow.
Thank you.
Ms. Hughley.
Thank you, Mr. Chairman. To the author of the bill, would you clarify for me your section 1, the basis of these findings that the General Assembly is making, and what are the sources that tell us these findings that you articulated in the bill?
These findings are actually already in code. They were placed into code in 2005. They are in 31-9A-4, almost verbatim to what is here, and it is in fact what we hand out each and every time a woman comes to a facility seeking an abortion. The findings are based on studies that have been conducted at different points throughout history and have been instituted, codified, and adopted by this body 7 years ago.
So, as we generally do when there is an update to what's in code, you're not seeking to update your findings to current information in this particular action?
I understand that there is a split of opinion on this, and I believe that we should err on the side of preventing abortions at the earliest stage at which there is good scientific evidence that a fetus can experience pain, which is 20 weeks.
I'm glad the gentleman admits his error.
Mr. Setzler. He waves. Any other questions? Thank you.
Thank you, Mr. Chairman. Thank you, committee.
Ms. Holmes.
Thank you, Mr. Chairman, ladies and gentlemen. The bill I'm bringing to you today is House Bill 751. It's on page 2, Modified Structure Rule. Provides that future elections for the office of judge of the probate judge of Jasper County to be nonpartisan. This particular probate judge serves as our election superintendent and feels that this could be a conflict of interest. I appreciate your
any questions?
Favorable consideration.
Thank you.
Thank you. Thank you, Mr. Chairman.
Okay, we're going to just go away from all tradition in the world and let a senator present his bill in front of those many, many House representatives back there. Mr. Staten.
Thank you, Mr. Chairman, for your great kindness. Good morning, members of the Rules Committee. I bring to your attention this morning to ask for your favorable consideration under Modified Open Rule, page 2, Senate Bill 268, regarding the Board of Education of Jones County. This bill provides that future elections for members shall be conducted on a nonpartisan basis. The request for this came to us from the school board unanimously. It has the unanimous support of the Jones County delegation. Representative Holmes is the House sponsor and will be carrying the bill should the Rules Committee grant us the privilege of having this on the floor, and I ask for your favorable consideration.
Any questions of Mr. Staten? Thank you. Wait a second. Mr. Chanel.
Thank you, Mr. Chairman. This is actually a question for the chair. I have great respect for Senator Staten, but in the Senate Rules meeting, do they put representatives in front of senators?
Boy, I tell you what, I sure do appreciate Mickey.
Just checking, Mr. Chairman.
It's certainly my intention that every representative be heard. Thank you,
Thank
Mr.
you,
Chairman.
Mr. State. Mr. McBrayer.
Thank you, Mr. Chairman and members of the committee. I bring to you on page 3 under structured House Bill 732, otherwise known as the annual tag bill. Section 1, it allows manufacturers of trailers to obtain a transporter license in order to pull a trailer to a trailer trade show, exhibition, or use in a parade. Section 2 would allow any Georgia resident citizen who is disabled to any degree and still currently serving in the armed forces to receive a free license plate and revalidation decals designated for disabled veterans. Section 3 adds the international symbol of access, which is the wheelchair on the blue background, to the Georgia's disabled veteran tag. Section 4 allows members of the armed forces or reserves who are still serving on active duty and have been awarded the Purple Heart citation to be able to be issued a Purple Heart license plate. Section 5 just simply provides a list of all the different military medal awards that have a special license plate for honorably discharged veterans and includes active service members as being eligible to receive those special vehicle license plate. Also adds the Afghanistan War and the war in Iraq, both the Iraqi Freedom and the Enduring Freedom operations, to the list of eligible military conflicts, and also adds those same trailer owners as being eligible to receive such tags. 6 creates a revenue sharing special license plate for prostate cancer awareness and research. And finally, Section 7 provides that certified firefighters shall be exempt from paying an annual special license plate renewal fee.
Questions? Thank you.
Thank you.
Mr. Harden.
Thank you, Mr. Chairman. Good morning, members of the Rule Committee. I bring before you House Bill 897, which is page 3, Modified Structure Rule. Basically deals with the federal program of Georgia Work Ready. The state never appropriated, but somehow over the time it found its way into code, and this is simply going to put the responsibility of oversight back into the hands of the 42-member board, which comprises of 2 House members, myself and Chairman England, 2 senators, et cetera, et cetera.
Any questions? Thank you.
Thank you.
Y'all, there's another one over there. And I see another one back there, Mr. Tippins. He's been coming forever, so he gets to go first. He knew the way over here, Mr. Heath.
Thank you, Mr. Chairman, members of the Rule Committee. I ask your attention this morning on page 2 under Modified Open Rules, 5th from the last, Senate Bill 138. I do want to clarify a couple of things about this. The bill originally had 2 parts. The description in this has to do with the part that was deleted. The part that's left in has to do with driving, the offense of driving without a license. And Representative Battles will be carrying this instead of Representative Bearden. So just wanted to straighten that out to start with.
I don't know, Bearden has a pretty good chance of getting them on the floor. Any questions, Mr. Tippins? Thank you.
You want a description of the bill, or?
No.
Thank you, sir. I appreciate it.
You've been coming.
Pardon?
You've been coming over here and letting us know how your wonderful smiley face in the mornings.
Thank you, sir.
Oh, Mr. Heath, you're next.
Thank you, Mr. Chairman, members of the committee. Just above the break on page 2, Senate Bill 343, relatively simple little bill to move the functions of the state accounting office to, move the functions of the Comptroller General to the state accounting office.
Any questions? The minority leader.
Thank you, sir. Mr. Chairman, is the Office of Comptroller currently included in the responsibilities of the Insurance Commissioner?
It is, and the Insurance Commissioner is agreeable to this change.
And this isn't a constitutional change?
It is not.
Thank you.
Thank you, Mr. Heath.
Thank you, Mr. Chairman.
You just come back anytime you want to.
Well, thank you, and you're always welcome in the Senate rules as well. We generally have a shorter line.
I've already talked to your rules, Chairman. We'll get those lines a little bit longer shortly. Mr. Cooner.
Thank you, Mr. Chairman, members of the committee. Under modified structured on page 2, House Bill 242, American Laws for Georgia Courts Act, which would require Georgia courts to apply Georgia law in domestic relation cases. I'd ask we can get that to the floor for a vote, and also reiterate the request on Senate Bill 343.
Any questions? Thank you.
Thank you, Mr. Chairman.
Mr. Pack.
Thank you, Mr. Chairman and members of the committee. The bill is in page 2, modified open, the third one down, House Bill 997. This makes a new crime for bringing false liens against public officials. This is commonly known as a sovereign citizens bill. Law enforcement interests have been battling these groups who are vigilantes who believe that they're not subject to the jurisdiction of the laws of any state or federal government. And one of the methods that they've been doing that is filing a nuisance false liens against law enforcement officials and judges. This actually creates a new crime and jacks up the penalties for doing so. I ask for your favorable consideration.
Any questions? Thank you. Ms. Clark.
Mr. Chairman, members of the committee, I ask for your consideration under modified open rule, page 2, sixth from the top, House Bill 1117. This is a population bill. If we amend the code from a population of 800,000 to 900,000, it would preserve the current schedule of conducting referenda on general obligation bonds for Gwinnett County and Gwinnett County Public Schools.
Any
I ask for your favorable consideration.
Any questions? Thank you.
Thank you.
Ms. Riley.
Thank you, Mr. Chairman. I ask for your consideration on page 1 under modified open rule, House Bill 928, that would allow the Board of Commissioners of the Peace Officers Annuity and Benefit Fund to hire a hearing officer for dispute cases. While this is not a fiscal bill for the retirement fund, it will result in a cost savings because having a hearing officer will significantly reduce the costs of going to court for dispute case resolution.
Questions? Thank you.
Thank you.
Ms. Scott.
Thank you, Mr. Chair, members of the committee. I'm here today to ask for HB 857. It's on the first page under modified open rule. This bill will require daycare centers to install safety alarms in vehicles used to transport children.
Any questions, Ms. Scott? We do have Ms. Cooper.
I did. Okay. Thank you, Mr. Chairman. Is this so if a child is left trapped in one of the vans time is set off by motion or what?
Yes, ma'am.
Thank you.
Thank you. Ms. Scott, you're good.
Okay. Thank you, and I ask for your consideration.
Mr. Teasley.
Thank you, Mr. Chairman, members of the committee. I bring before you two bills, both under modified open on the first page, House Bill 945 and 946. They were requested by the Department of Banking in 945, essentially giving, as they put it, more tools in the toolbox to allow for banks that need to infuse more capital into their banking, into the local bank. And then in House Bill 946, some restrictions on, it's basically tightening some regulations on mortgage lenders who had engaged in illegal behavior in other states, trying to tighten the restrictions on them being licensed here in Georgia.
Any questions? Thank you.
Thank you.
Mr. Flood.
Thank you, Mr. Chairman, members of the committee. House Bill 816 is not on your list. According to the staff, it was inadvertently omitted. But House Bill 816 essentially expands existing law where we have the ability to provide preferences in state procurement contracts for products that are made in Georgia. This would expand that preference to products that are made in the United States of America.
Questions? Thank you.
Thank you.
Mr. Battles.
Thank you, Mr. Chairman. House Bill 871 under modified open rule is just simply what is referred to as Joshua's Law, and we're just extending that date from June 30th of 13 to 2018, and that's the only thing we're doing on that particular bill. It's just a date change.
Any questions?
And then lastly is House Bill 1056 already presented. That's a revenue bill. Just ask that you would consider moving it on. And that's it, Mr. Chairman.
Any questions? Thank you. Mr. Shaw.
Thank you, Mr. Chairman. I've got a couple of insurance bills to ask about again today. House Bill 513 under modified open rule on page 1 deals with discretionary groups for life insurance. Same regulation that we have now for group health policies to allow for discretionary groups at the based on the recommendation of the Department of Insurance. Also, House Bill 931 deals with domestic county farm mutual insurance companies, allows more consumer choice in the marketplace. Also, at the discretion of the Department of Insurance to allow those companies to write more coverage based on their assets.
Questions of Mr. Shaw?
Thank you.
Y'all, he's back. Mr. Hatchett.
Thank you, Mr. Chairman. I bring to you House Bill 863. It's the Small Business Assistance Act of 2012. Raises the no-bid small value for the Department of Administrative Services from $5,000 to $25,000. And it also addresses the definition of a small business when it's involved in the bidding process with the Department of Administrative Services, where they can actually designate that. And I do have an amendment to this bill at the appropriate time. I'm not sure of the protocol there.
Now's the time.
Have an amendment that actually changes the limits for small business, the number of employees from 500 to 300, and the gross revenue per annual revenue from 50 million to 30 million. It also adds a sunset clause into the entire bill. It sunsets July 1st, 2015.
Any questions? Thank you.
Thank you, Mr. Chairman.
Members of the committee, Willard.
Thank you, Mr. Chairman. I've got three matters I want to ask for this morning. First is House Bill 641. This is the rewrite of the juvenile code. Next one is House Bill 1049. This is to assist the local governments with the obtaining the amounts that are due them for the 911 services fees. And I'd like to also ask for a bill, HB 844, that Representative Martin he asked for yesterday. This is on the bonds. These are all on the third page, Mr. Chairman.
Any questions, Mr. Willard? Mr. Golett.
Thank you, Mr. Chairman. Under modified structured on page 2, House Bill 648, and then on page 3, H.R. 977. This is the indigent defense package, the constitutional amendment that will authorize the General Assembly to go ahead and dedicate the funds from the indigent defense system for the purpose of indigent defense. That's about $40 million. It's constitutes 0.002 of 1% of the budget. It does not preclude the General Assembly from coming back at a future time and changing the formula whenever it sees fit. And I also have an amendment that will pass out at the appropriate time, if it's appropriate this morning, that will ensure that any excess funds at the end of the fiscal year will go back into the general fund, just as with any other agency. That amendment is signed by all members of the leadership, Chairman England and Chairman Powell. Thank you, Mr. Chairman.
Mr. Lindsay.
Thank you, Mr. Chairman. I'm requesting a bill at the request of Chairman Martin, bringing up a bill from another committee, House Bill 920 on page 3. Simply required from the Office of Planning and Budget additional analysis regarding tax breaks that we give to various entities on the promise of certain things happening, such as visits coming in or additional tax revenues somewhere else. It requires that there be periodic review of those tax breaks to make sure that they're doing what they're supposed to do.
Mr. Chair, your mics up there not working, because we can't hear you guys. In the back of the room.
Mine keeps turning on and off. It collapses down.
Speaking to the next one.
Basically, HB 920, I apologize. Basically, House Bill 920 simply requires the Office of Planning and Budget to periodically review those tax breaks that we pass under promises of certain positive economic things happening, making sure that they in fact do happen, so that we can then make decisions in the future as to whether or not to continue those various tax breaks.
Okay. Mayor Pro Tem. Mayor.
Thank you, Mr. Chairman. Wanted to ask
Speaker.
for House Bill 990 under modified structured. It clarifies existing law related to a new city that if the transfer of a park that was a park at the time of the incorporation would still be treated as a park. We have a park up in my area that has been deemed a hazardous waste site for the last 7 years. But the second is finally clarifies that some minor remaining funds would be transferred over due to prolonged property tax valuation disputes. There was no opposition to this in the committee.
Thank you. Mr. Earhart.
Thank you, Mr. Chairman. Two propositions. One, I know you're reticent on, and the other is House Bill 898, the merchant acquirer's banking proposition. I'm open to either one.
Talk to me about those banks.
I think you want me to explain the banking.
No, I think you did a wonderful job yesterday, and I think everybody, since we'd never heard of that, we now know what that is. We now know what that is. Is that better if I'm here, or you like it done here? Okay. How about right here? Are there any questions of Mr. Earhart? If there is questions, remember, since you've all got your little buttons pushed, raise your hands if you've got questions. Okay. Ms. Sheldon.
Thank you, Mr. Chairman. I ask that House Bill 748 be recommitted to judiciary. Representative Brockway is making that request. I'll make it on his behalf. And also, I'd like to request House Bill 1026, a population bill that only impacts Gwinnett County.
Anything else? All right, she's got a motion to move 748 back to committee. Anybody with a problem? All right. Mr. Rice.
Thank you, Mr. Chairman. This is another population bill, HB 1024, under modified open. Just keeps things as they were, as it was, and all the large counties are agreed.
It sure would be nice if there's a way we could put those together, but I don't think we can.
Different code sections.
Okay. Mr. Cassis.
Thank you, Mr. Chairman. House Bill 792, the authorization by means of accreditation for non-public post-secondary institutions in the state of Georgia.
Questions? Ms. Abrams.
Thank you, Mr. Chairman. I have two requests. At the appropriate time, I'd like to offer an amendment to HB 954.
That time is right this second.
It
doesn't matter. Y'all, it's not, it doesn't matter.
There is an amendment that the staff has. Unfortunately, I neglected to sign it, but if, with your permission, they can pass it around.
My permission is granted.
Thank you. As the amendment is
Wait
being...
just one second. I'm going to let you yield to across the hall from you there, Mr. Earhart.
Just a clarification, Mr. Chairman, isn't it true that if this were to be amended, it would become a modified structured proposition at that point? Right now, it is under structured rule. If, for some reason, Representative is successful with the amendment, then this would drop down into a modified structure, and the bill would go with an amendment to the floor.
The chairman knows of what he speaks. To clarify to y'all, if we vote on this amendment in a few minutes, this bill is structured on your blue sheet. If you vote on the amendment and it passes, it goes to the floor modified structure. Everybody up with that? Ms. Abrams.
Thank you, Mr. Chairman. The amendment before you acknowledges the intent of the author, but recognizes that there's medical information that was not available in 2005 that is now available in 2010. And I would point out to this body that we have a number of times in this room updated the code to reflect new information, including changes to the electronic devices that are allowed in schoolrooms, because we recognize that what was true in 1998 is no longer true today. So putting aside any concern or question about the viability, the question of abortion rights, we believe that this amendment adequately and accurately reflects the medical information, which is that an unborn child at 24 weeks is more in accordance with the appropriate standard of care. Furthermore, as the author acknowledged in his testimony in response to my questions, medically futile pregnancies are not protected in the current bill. A medically futile pregnancy means any pregnancy that could not, at the time that the fetus is delivered, be a medically viable birth. But under the terms and conditions of the bill as it stands before us, a woman would be forced to carry to term a child that is not medically viable, would be forced to accept congratulations and would basically be forced to treat the fetus within her as medically viable, even though she and her family know it not to be true. In addition, it causes and could create medical problems that, until it reaches the stage of sepsis, could endanger a woman's life, essentially forcing her to have a stroke or to have some other medical condition before she is allowed to undertake what any reasonable doctor would call a necessary medical procedure. So we ask consideration of this amendment, which would simply change the language from 20 weeks to 24 weeks, and would also recognize that medically futile pregnancy should be exempted from this bill. And I ask for consideration.
Okay. Mr. Setzler.
Mr. Chairman, I just want to remind members of the committee that these issues were addressed extensively in our full committee. That in fact, any condition that could lead to a serious physical condition to the mother, such as the condition the lady describes, are allowable in this bill. The 24 weeks, as she has it defined, is actually a 26-week abortion as it's defined in the bill. The testimony about medically futile pregnancies, I would submit I'll leave that to every member to decide for themselves. I would simply say that there are more than 1,000 children per year that are viable to be brought to term, that are covered and protected by this bill, that this particular amendment would leave unprotected.
Thank you. Mr. Mitchell.
Thank you, Mr. Chair. I bring to your attention again on I'm sorry, Mr. Chair. I'm not. I don't have a dog in this fight at the present time. I thought you were entertaining requests.
This is not a fact. Those two issues are over with. Let's go to what you want. No rebuttals. At the proper time, I'll take them.
And once again, thank you, Mr. Chair. I bring to your attention on page 2, House Bill 673, Georgia's Return to Play Act, which simply establishes a return to play protocol for those who have suffered from or suspected of having been suffering from a concussion. And while I have the mic, Mr. Chair, I'd also like to put my name by House.
You get to go on. I said I wasn't putting names by. That's good. Who's next?
Thank you, Mr. Chairman. I'm behind the gong. I bring to our committee today.
So is Golick.
I bring to our committee today on page 3, just below the second hole punch, House Bill 1102. This is known as the Reuse and Redevelopment Act. We commonly refer to it as the Brownfields State Program. It was first introduced in 2002. In 2005, it was modified with the clarification, and in 2012, we're revisiting it. It was presented, this change was presented before the Red Tape Watch Committee, chaired by Chairman David Knight. The purpose of this program, of this modification, is to give a 30-day grace period after the property is purchased. Right now, the way the language reads, you have to, first of all, this is private money, private investors. There's no state money or federal dollars involved, and it's voluntary remediation. So this is with the agreement of EPD that the person purchasing the property can do it after the purchase, and it gives a 30-day grace period so that the purchaser can enter it into the Brownfield program. This is needed because since 2008, there are just no willing investors with this particular situation. It is good jobs for our community, both small and large. You can see it revitalizing corners where there are gas stations or dry cleaners or larger areas. Thank you, Mr. Chairman.
Mr. Roberts.
Thank you, Mr. Chairman. House Bill 836 is just an oversight committee that we used to have in place at sunset. This puts it back in place and does allow for sunset. Answer any questions.
Mr. Benton. Mr. Benton.
It's Representative
Both of them on. Ms. Manning.
Mine's on Representative Manning cannot speak, Mr. Chairman, so I am her voice today. She is asking for House Bill 745 under modified structure, page 2, and House Bill 681 under modified open, page 1. Thank you, Mr. Chairman.
Mr. Weldon.
Thank you, Mr. Chairman. I'm asking for where is it? Let me find my bill.
Is this your bill?
It's Can you come back to me, Mr. Chairman?
Okay. Ms. Abrams. Okay. I'm back to you, Bubba. You're the last one on the list. Mr. Weldon wants to ask for something. We just don't know what it is. That's a real good idea. All right. Here we go. All right. Take him off. All right. We've had 2 amendments offered on 2 bills this morning. The first bill is under modified structure 863. An amendment was made. Do I hear a motion on that amendment? Any opposed to that amendment? All right, the amendment's on there. And then the other one is under structured 954. You've had an amendment there. Do I hear a move on the amendment? Do I hear a second? Have a motion and a second. All those in favor of the...
Can I make an inquiry, Mr. Chairman?
Yes.
An inquiry to the author. Inquiry to the author. Is the author willing to amend her amendment to take it to 20 weeks as opposed to 24? Yes.
Yes.
Can I make a motion to...
No. I'm done.
To amend her amendment?
Y'all, we've got the amendment out there. We've got a motion and a second. All those in favor of the amendment say aye. Now you've got an amendment that changed that, the original bill. I got a motion and a second from, I want to know all those people in favor of the amendment. Raise your hand. 1, 2, 3, 4, 5, 6, 7. All right, all those opposed to the amendment. The amendment does not pass. All right, we're going to set the calendar. Under structured, HB 954, do I hear a move? All those in favor signify by aye. Aye. Opposed? No. It's on the calendar, structured. Under structured, HB 641, do I hear a move? Third. All in favor? Any opposed? Blew that one. It's on. Under structured, HB 289, do I hear a move? Any opposed? It's on. Under modified structure, SB 339, to remove. SB 339. Any opposed? Motion carries. Under modified structure, HB 990. Any opposed? So, HB 898 under modified structure. Do I hear a move? Move. Any opposed? HB 863 is amended. Do I hear a move? Move. Any opposed? Motion carries. It's on, again, under modified structure, HB 817. Do I hear move? Any opposed? Under modified structure, HB 751. Do I hear move?
Move.
Any opposed? It's on. Modified structure, HB 520. Do I hear move?
Move.
Any opposed? Under modified open, HB 208. Do I hear move?
Move.
Any opposed? Under modified open, HB 513. Do I hear move? Any opposed? Under modified open, HB 746. Any opposed? That is your calendar for tomorrow. Wait a second. Whoa. Got it. Mr. Gurley.
Thank you, Mr. Chairman. Pursuant to Rule 33.3, I move that we, the House Rules Committee, limit debate on House Bill 954, debate not to exceed 2 hours, time to be allocated by the chair.
You have a move to limit debate on 954, 2 hours at the discretion of the speaker. All in favor signify by aye.
Aye.
Any opposed? Motion carries. Motion carries.